this first appeal was listed day before yesterday on 19, my lord, for admission. Due to paucity of time, the matter could not be taken up. So before rising, my lord, I made a prayer for listing for yesterday. Your lordship allowed it for today. There is an order, my lord. But since the matter is not listed today inadvertently, may I pray, my lord, this may be listed on 25. There is some urgency, my lord.
If you mean,
Itu? FAO my lord, FAO is assigned to your lordship's, my lord. Accordingly, it was listed also, my lord.
yes,
It was listed.
okay.
Obliged, my lord.
My lord, I would like to mention item 9 for adjournment.
Why?
My senior is out of station. Already, I have consult with. opposite party.
Number 1.
Mr. What is your name?
A.S. Ahmed.
A.S. Ahmed, learned counsel for the appellant, who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the appellant. Also, Mr. A. Kakuti, the learned counsel for the respondent number 1, who does not raise any objection. Stop, hence the prayer is allowed. Let this matter be listed after a week on a date to be fixed by registry.
After 2 weeks.
After 2 weeks on a date to be fixed by registry.
Okay.
Your Lordship, with the consent from the petitioner, I beg to mention item number 8. The arguing counsel, due to the flood, is unable to appear today.
You are appearing for whom?
And the for the respondents.
You have informed. What is your name?
Oh, Asumi.
Heard Miss O.R. Sumi, the learned counsel appearing on behalf of Mr. N. Datta, the learned counsel for the respondent, who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the respondent. She submits that she has informed learned counsel for the petitioner regarding her prayer for adjournment, who does not have any objection to the same. Hence, the prayer is allowed. Let this matter be listed after 2 weeks on a date to be fixed by registry.
May I beg your Lordship? I beg to mention item 2, Lordship. Finally, the matter may be adjourned for the day, as my senior is, due to some personal difficulties, he could not appear today.
Heard Miss
R.
R.
Shaha.
R. Saha, the learned counsel for the petitioner, who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the petitioner. The prayer is allowed. Let this matter be listed in the next week on a date to be fixed by registry.
May please, Your Lordship. I beg to mention the MAT appeal. The matter was last listed in the year 2025.
MAT appeal, court number 8.
And CRP.
May it please your Lordship. Lordship, I beg to mention item number 42. My senior D. Mohanta has some personal difficulty. Kindly fix the matter after 2 weeks. 42, Lordship.
You have informed the other side.
Yes, Lordship.
Heard Miss
D and Das.
B and Das.
D and Das, Lordship.
D.
D.
Heard Miss D and Das, the learned counsel appearing on behalf of Mr. D. Mohanta, the learned counsel for the applicant, who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the applicant. She submits that she has informed learned counsel for the respondent regarding her prayer for adjournment, who does not have any objection to the same. Hence, the prayer is allowed. Let this matter be listed after 2 weeks on a date to be fixed by registry.
Bless Lordship.
The beg to mention item number 53. I am on behalf of the respondent. They have taken consent from the other side. It may be adjourned. In supplementary.
Heard, Mr. What is the name?
DK Agarwala on behalf of Jed Hussain.
D.K. Agarwala, appearing on behalf of Mr. Z. Hussain, the learned counsel for respondent number 2 and 3, who press for an adjournment on the ground of personal difficulty of the conducting counsel for the respondent. He submits that he has informed the learned counsel for the applicant regarding his prayer for adjournment, who does not have any objection to the same, hence the prayer is allowed. Let this matter be listed after 2 weeks on a date to be fixed by the justice.
Grateful.
Lordship, I beg to mention arbitration appeal number 2 of 2025 for urgent listing. I'm appearing on behalf of RDB from appellant side.
What is the urgency?
Lordship, I don't have the correct, proper instruction according
No,
to the-
when your senior asks you to mention, ask him to brief you properly. Otherwise, you will be in trouble.
I will be careful next time.
Okay.
And also arbitration appeal number 4.
Next week on a date to be fixed by the justice. Next week.
Any fixed date if Monday is possible.
26th August.
Also, Lordship, arbitration appeal number 4 of 2025.
What is the urgency?
It is the same party, Lordship.
No, you mention it in the afternoon after getting instruction regarding the urgency. You mention it in the afternoon.
Jobless.
Yes.
Wait, Lordship. My lord, item 19. I have some difficult day. It may kindly be listed next week, any day. My learned friend is here.
Inform the other side.
Lordship, I am.
Heard Mr. M.U. Mahmood, learned counsel for the petitioner, who prays for an adjournment on the ground of personal difficulty. Mr. S.K. J. Abbas, learned counsel for the respondent, does not raise any objection to the prayer. Hence, the prayer is allowed. Let this matter be listed in the next week on a date to be fixed by registry.
Can it go on 28th if not realized? 28th, last day of next week.
28th. 28th.
Obliged, Lordship.
Lord, in this case, I am as a caveat on my lord. One objection, my lord, the entire revision petition, penultimate page is not provided to me. Penalty? The decree. Where is it?
Last page.
Yeah.
Last page means page 88.
53, 54 hours. Degree, page 50, from 53, 54.
Last page is 88.
It is not matching, my one.
My only thing, my lord, here, the
Penultimate.
decree is there, my lord. Now, what happened between these two parties, my lord? Now, respondent has filed a suit against us. And in that suit, my lord, both the party contested and suit was dismissed. Then, my lord, respondent filed an appeal, title appeal, before the learned trial affiliate court, my lord. In that appeal, my lord, appeal was allowed and remanded back the suit for fresh consideration with taking the fresh consideration of evidence. In that second round of litigation, my lord, suit was decreed in favor of the respondent plaintiff. And when, my lord, this suit was remanded back by the trial affiliate court, it was direct to the parties to appear before the trial court. So when this matter was remanded back, inadvertently due to some, my lord, communication gap between the counsel and the defendant, my lord, defendant, my lord, did not appear before the trial. So the second round of suit, my lord, suit was decreed ex parte.
Okay.
Now against that ex parte, my lord, when already and after that ex parte decree, my lord, they file an execution before against us. So when notice for against the execution come up, then only we came to know and we approached the trial court by filing an application for setting aside of the ex parte order.
Okay.
That was also rejected. Against that, my lord, we have filed a misappeal
Okay.
before learned trial appellate court. Trial appellate court admitted that this appeal, my lord, and initially, my lord, stayed a title execution proceeding. And in the subsequent date, my lord, that stay order has been vacated. So against that vacating order, my lord, we are before this honorable court.
Where is the impugn order?
My lord, come to page 86, my lord. My lord, first, lordship may come to page 84. Annexure 8, my lord. Page 84. This is the original copy, my lord. I have annexed the, my lord, type copy also, page 82. May I read, my lord, page 84?
No, this is not the impugn order.
No, this is the, my lord, first order whereby, my lord, stay has been granted in a miss appeal.
Okay, read it.
Yes. Order dated 29/7/26, my lord. The appeal is preferred under order 43, rule 1R of Review section 104 of CPC against the order dated 21/7/26 passed by the learned civil judge so-and-so in miss case number Iman. The appellant prayed to admit the appeal, issue notice to the respondent, call for case record, and after hearing the parties to set aside the impugn order. Third learned counsel for the appellant peruse the case record. The appeal is filed within limitation period, and appellant said out good ground in favor of the appeal. Hence, the appeal is admitted for hearing. Call for records of miss case so-and-so from the Court of Civil Judge Unit in Koliago. The appellant has also filed a petition bearing number so-and-so, wherein they had prayed for staying the title execution number 5/25, which was filed in consequence of the judgment and decree dated so-and-so by showing ground that the learned trial court rejected their application for setting aside the ex parte decree passed in title suit number so-and-so, and against the said rejection, this appeal is filed. And the petitioner had further stated that if in the meantime the execution is done, then the very purpose of the filing this appeal will be frustrated. Heard learned counsel, considering the grounds shown in the petition, title execution so-and-so stay only up to the next date, and an order on the final stay will be made only after hearing both the sides. Appellant to take step for issuance of notice upon response 3. Then, my lord, come to page 84. This is the impugn order, my lord.
86.
86, sorry. Order dated 12/8/26, my lord.
Yes.
Appellants are present, respondent had appeared, and they are represented. Today is fixed for further hearing on petition number so-and-so, wherein in the previous date a limited stay was granted till today, and the matter of final stay was kept pending till today. Hard learned counsel of both the side on the petition bearing so-and-so, wherein the appellant pray for staying title execution number so-and-so. Peruse the petition bearing number so-and-so, and perusal of the same shows that the petitioners contested the original suit as defendant, which was dismissed, and thereafter the plaintiff of the case filed an appeal, which was numbered as TA number so-and-so, and the same was allowed, and the matter was remanded to the original court with a direction to both the parties to appear before the learned trial court, and herein the petitioner have contended that they did not know about the aforesaid direction to appear in the trial court, and that their learned counsel did not inform them about the same, and thereafter they came to know about the execution proceeding. Now, from the petitions of the petitioners itself, it is quite apparent that they initially contested the original suit, and they also contested the title appeal, in which the case was remanded back to the trial court. But though they contested both the original suit and thereafter the subsequent appeal, they very conveniently pleaded ignorance about the direction to appear before the trial court again, and they very conveniently pinned the blame on the previous learned counsel. Now, as the petitioner contested the original suit and the subsequent appeal, it is hard to believe that they were ignorant about the direction of the appellant court, and therefore, furthermore, the learned counsel for the respondent had, during hearing, submitted a certified copy of the judgment of the appellate court, wherein it is seen that learned advocate J. Ligira was one of the counsel in the appeal, and this instant misappeal is also filed by learned counsel J. Ligira, which countered the version of the appellant, and their counsel did not inform them about the direction to appear in the trial court. And it seems that in spite of the direction of the appellate court, the appellant of this case did not appear, for which a judgment was pronounced, and thereafter the execution case was filed. And it is taken into consideration that the plaintiff has been contesting the case for a very long time, and thus, considering the same, and also considering that the appellant did not appear before the trial court in spite of specific direction, this court does not deem it fit and proper to stay the execution case so-and-so, and according to the petition that the so-and-so rejected, and consequently the interim stay order in the previous order stand vacant. This court would like to further opine out this appeal going in favor of the appellant, and in case of the subsequent proceeding. Lord, this is the order. My lord,
What happened to Miss Appeal?
it is already admitted and pending for final disposal.
Miss Pending.
My lord, my only limited prayer is, my lord.
So Miss Appeal has been decided.
Yes.
And indirectly.
Yes. And by this order, my lord, already misappeal has been decided on merit, my lord. In this order, it reflects.
Yes, Mr. Ghosh.
My lord, this is not ex parte, my lord. It was contested.
Which was?
This judgment which is under challenge before,
No,
Under
if
order 9
you,
rule 30.
if you go through the impugn order passed under order 41 rule 5.
No, I'm coming to the initial stage. After remanded, my lord, when the appeal was allowed by remanding to the learned trial court, my lord,
No, the appellate court could have decided the misappeal instead of expressing everything in order 41 rule 5 application.
my lord,
It has indicated its,
the order 9 rule 13 application is not maintainable, my lord, because it is an inter-party decree, my lord.
no, that could be contested in the pending appeal.
I'm coming, my lord. It was an inter-party appeal. Then they file an application order 9 rule 13 before the learned trial court. Trial court, after going through the record, as well as apart from that the learned counsel, here is the stand taken that learned counsel has not informed to them that in the trial court also, the
Ligira.
remand, someone was served. Then thereafter, case has been decided, and in the decree, my lord, kindly see who are the decree holder.
No, no.
No,
The-
kindly see who are the decree holder, my lord, and who has prepared order 9 rule 13. My lord, kindly see the decree. That decree has not been annexed in my petition, my lord.
Kuntu decree আছে?
Order, it may be at page.
Page,
My lord, that decree is in page 54, my lord.
why have you not furnished a copy?
Page 54, kindly see, my lord. I have no page for page.
মই দি দিম বাৰু।
Page 54, kindly see. Kindly see the respondent, defendant therein, my lord.
Yes,
How many defendants? 13 defendants.
yes.
And decree, kindly see the decree. Declaration of right title interest over the suit, Schedule A land, declaration for recovery of possession of the suit, Schedule A land by evicting the defendants.
My lord,
And-
originally this party are there. They are the defendant, my lord.
They evicting the defendants and by removing the construction
Yes.
made by the defendants in the suit Schedule B land. Lordship got it?
Yes.
Now kindly see the petition who has filed. Order 9 rule 13. At page.
70.
My
Wait,
page
no,
is
no, no,
page-
no, no, no.
59.
Yes, yes.
My
15.
page is 58. Kindly see,
59.
Krishna Chandra Das, Minoti Das and Virendra Das.
Not, my lord, this,
These 13 defendants,
all, no, my lord, no, all
No,
defendant not.
let him submit.
Yes, no.
13 defendants against 13 defendants, decree has been passed.
Yes.
And now after passing of the decree, this petition has been filed by 3 persons. And in the main suit, my lord, our case is that these persons, this only applicant number 1, by executing 2 sale deed in favor of me, they have left the place and they are not in the respective in the scheduled land, my lord, by giving the possession. The other defendants who are not filed any application, they have been dispossessed as, and they have not filed any application, my lord. So under such circumstances, my lord, the trial court, after going through the record, it is held that since it is an inter-party appeal, kindly see the judgment, my lord, whether it was ex parte or inter-party, my lord. Judgment, my lord. Page 43. Lordship got it? A.K. Singh, learned counsel for the plaintiff, and J.R. Goswami, learned counsel for the defendants. So they have not challenged this decree on merit, my lord. Because order 9 rule 13 only goes whether it has been ex parte or not, whether ex parte has been rightly granted or not. Merit they have not challenged. And
No,
three,
but they have challenged Order 9 Rule 13,
it is
rejection of their prayer under Order 9 Rule 13 in
kindly
the
say
appeal.
order
My lord,
party.
my lord,
It is
my,
not
my
ex
case.
parte.
Let me put queries.
My lord.
They have, when Order 9 Rule 13 application was dismissed,
Yes,
they preferred a misappeal.
misappeal.
When misappeal is pending, the misappeal ought to have been decided. In the Order 41 Rule 5, you have ultimately decided the misappeal by,
No, regard,
Yes.
not misappeal, stay of the execution.
but you have given reasons which will be applicable to misappeal also.
My lord,
Yeah.
with that observation that this order will not affect the main merit of the main appeal, my lord.
No, my
It
lord,
will
main
go into the
contention,
entire merits of the case, my lord. This order which has been passed will not touch the merit of the order, the appeal which has been filed order 43-1. Without touching into the merit.
my lord, I have filed a application, my lord, misapplication, my lord, misappeal. Here also the ground is same. The ground, my lord, on the ground of this learned council, this,
When is misappeal is fixed?
my lord, misappeal is fixed on 31/8, my lord. Last page, page 88. Now, my lord, only my prayer in this case, my lord, since the misappeal is pending, and now in this order, my lord, in the impugn order, now the learned trial court, my lord, already decided the matter, my lord, which has to be decided in the misappeal. My lord, so my limited price, my lord, till my lord disposal of this misappeal. my
Whether
lord.
appearance of parties is complete
Yes, yes.
in misappeal.
After
Yes.
hearing, we file objection, then stay has been
So,
vacated.
so it is for hearing.
My lord, it is for hearing.
With respect to misappeal, my lord.
Yes.
Not with respect to stay of the execution of the decree. Then we file application that stay order which has been passed may be vacated. That has been vacated by the impugn order.
No, if misappeal is disposed of,
Not disposed of.
listen, suppose misappeal is heard and disposed of, there will be no embargo on proceeding with the execution. Now, if misappeal is decided in favor of the present petitioners,
That
again,
observation, my lord, under restoration
restitution.
Oh, yes.
My lord, that will create another
144.
round of
Because in the
litigation.
merit, my lord, they have not touched to the merits of the judgment, my lord. Because your lordship know, order 9 rule 13 is an ex parte, whether it is an ex parte or not. That is to be decided. Suppose it is an ex parte. I have shown from the judgment it was not an ex parte order. It
My
was
lord,
inter
that has to
parte
be decided by the
and-
learned trial appellate court, my lord, in my misappeal, my lord. Now misappeal is, my lord, admittedly, it is admitted by the learned trial appellate court. Now the question is whether, my lord, during pendency of the misappeal, before learned trial appellate court, whether this execution can be proceeded. Now my prayer is very limited in this petition, my lord. I am not coming on merit. Now the question is already initially, my lord, the learned trial appellate court, my lord, granted the stay. And subsequently, my lord, my passing an order, which is already, my lord, it is amounting to disposal of the misappeal, my lord. Now the reason given in this impugn order, it is amounting to, my lord, order judgment passed in the misappeal.
My lord, I am giving one judgment of Supreme Court, my lord.
So, my lord, my only
What
prayer
the
is,
scope under order 9 rule 13? The scope under order 9 rule 13 is the
No, this is to be decided in the misappeal only.
yes,
misappeal. Now kindly see the judgment, trial court, whether it is a case of order 9 rule 13 or not.
No, that question we will not go into now.
But prima facie, my lord, prima facie from the materials on record, it shows it is not beyond the record, my lord. Prima facie shows that it is not, it is an interpretive.
No, Mr. Ghosh, that is for the appellate court to decide.
That is appellate.
If we make an observation now,
But suppose stay of the execution is stayed, my lord. That is only with respect to he has come for stay of the execution case.
yes,
Now, there must, for stay of the execution, there must be satisfaction that there is a prima facie case. It may, there is a statement is given in the execution
yes.
that there are sufficient
Yeah,
ground for
but-
allowing the appeal.
But
That sufficient ground, I am showing that from the record that there is no sufficient ground. Because order 9 rule 13, interparty decided, my lord. Page 43, kindly see. It is not then ex parte.
you want to file any objection in this case? Or we can dispose it of today?
My lord,
We may dispose it of with a direction. What I am intending, direction to the appellate court to decide the appeal on the next date fix and accordingly proceed with the ex parte. Till then, the execution may have.
my lord, then I'll file Monday, I'll file objection that.
Okay, let
No,
him
my
file.
lord, what?
Monday, my
What
lord.
my
I'm
lord-
not
No, my lord,
taking
I'm not
1 day
objecting
time,
on
my lord.
Monday, my lord. As per my information, my lord, today they are going to, my lord, execute the my lord, decree.
No, no,
Wait,
that.
wait,
That is the information, my lord, I
No,
have
no,
Where is the statement?
Correct.
Today,
today, my lord.
where is the statement?
That statement, my lord, I have already given in my petition, my lord.
Mr. Singha, you are at fault in not furnishing copy.
My lord, I will furnish, my lord. My lord, already I have annexed.
Therefore, you are not entitled to get any interim.
No, my lord, that is, my lord, I'm sorry, my lord, I'm sorry on
Let
that
him
part.
file on Monday. We'll dispose it of on Monday.
My lord, my lord, I don't have any objection to that effect, my lord. Because somehow, my lord, inadvertently, some pages have been, my lord, by mistake, my lord, has been left from his petition. I will, my lord, start the copy. Lordship may kindly come to annex,
Because
page
the
14.
Decree against whom the decree was passed.
My lord, lordship
They
may,
have not come under.
my lord,
order
I have
9
had
rule
no
13.
objection, my lord, if lordship, my lord, directed the trial appellate court to decide this appeal. My lord, on the next day.
Next day is Monday.
Monday,
Monday.
Monday, I have
My
no
lord,
objection.
because why I'm saying, my lord, today they are, my lord, going to execute this decree, my lord. That's why I'm, my anxiety is on to that effect.
Then we'll dispose it of with a direction that decide it on 31st.
Monday, my lord, it may be, because I will file.
So in
only
that case, my lord,
objection
my,
to that aspect that the decree holder, judgment debtor has not come under order
my
9
lord,
rule 13.
kindly see page 14, my lord, para 9, my lord. I have specifically stated.
Heard Mr. K. Sinha, learned counsel for the petitioner. Also heard Mr. S. K. Ghosh, learned counsel appearing for the caveator / respondent. This application under Article 227 of the Constitution of India has been filed by the petitioners impugning the order dated 12/8/2026 passed by the Court of Learned Civil Judge Senior Division Nogao in Miss Appeal number 12/2026, whereby the interim stay granted on earlier occasion on
29/7,
in execution on 29
7/26.
29/7/26 in title execution case number of further proceeding of Calicut. Stop. So in 29 of further proceeding of title execution case number 5/2025 was vacated. Stop. The Mr. S. K. Ghosh, learned counsel for the caveator, has submitted that though the copy of this revision petition has been furnished to him by the petitioner. However, it is some pages in the annexures are missing. More specifically, the decree which is put to execution, copy of the decree which is put to execution is not furnished. He also prays for allowing the respondent to file a written objection by he, and for the same he prays for 3 days time and further prays for listing this case on next Monday, that is on 31st August 2026. The prayer is allowed. The respondent shall file his written objection on Monday with an advance copy, on next Monday with an advance copy of the same to the learned counsel for the petitioner. Stop. The learned counsel for the petitioner is directed to furnish the missing pages of the annexures annexed in the instant petition to the learned counsel for the respondent during the course of the day.
My lord, till
During
date
the
kindly
course of the
protect that.
day. Considering the entire aspects of this matter, the execution, the proceeding of title execution case number 5/2025 shall remain stayed till next Monday, that is
My
31/8/2026.
May I pray one thing? Since the case is fixed on Monday, my lord, this Monday, before the lower appellate court. Let the lower appellate court decide on that day, my lord. Till then, stay may be granted and case may be disposed of.
It is, however, made clear that only the further proceeding of title execution case number 5/2025 has been stayed, and there is no stay in the proceeding of Miss Appeal number 12/2026. Stop. The Appellate Court of Learned Civil Judge, Senior Division, Nagaon, shall make all endeavor to dispose of the said appeal as expeditiously as possible, preferably on the next date itself. List accordingly.
Then, my lord,
But
this
disposed of, till then, stay, till this,
You are not opposed to,
because it is fixed on 31st.
then we are disposing of this.
Disposed.
or my lord, let decided in the
No, no.
let the trial court decide on Monday.
Not
This
trial
matter will fix on my lord 26, my lord.
No, no, I have no objection to dispose of.
Last para पढ़ो. SK Ghosh, from SK Ghosh. Right again. Mr. SK Ghosh, learned counsel for the respondent submits that since the miss appeal number 12/2026 is fixed for hearing on 31/8/2026. And
My
since
lord, it is fixed for on 31/8/26 for TCR, that means trial court record. If the record is not available, I think, my lord, in that day, on that day also, the hearing will not be. Because as per record, my lord, this 31/8 is fixed for TCR.
okay, let the earlier order prevail. We will
Yes,
see
sir.
what you file objection. We will decide it on. We'll dispose it of on Monday,
PCR का मतलब-
next Monday.
Not Monday, my lord, if
Since your
my lord,
lordship
possible at
has
26, my lord.
staying
On
the
Monday, I will
execution,
be
my
some
lord.
other difficulty.
Your lordship is staying the execution till disposal of the title appeal,
Miss appeal.
miss appeal
Okay.
as expeditiously as possible
You are not,
within a period of 1 month.
Oh, yes. That,
Kanika, Mr. SQ. Is fixed on 31st August 2026. And since both the parties have already appeared before the appellate court, he has no objection if this if this revision petition is disposed of with a direction to the appellate court to dispose of the appeal as expeditiously, to dispose of the appeal expeditiously. Stop. In view of the submissions made by learned counsel for the respondent, this CRPIO is disposed of with a direction that the Appellate Court of Civil Justice Senior Division Nagaon shall dispose of the miss appeal number 12/2026 as expeditiously as possible, preferably within a period of
1
2 months.
1 month, because LCR has already received. my lord.
Within a period of 1 month from the date of this order. Stop. Till then, further proceedings of title execution case number 5/2025 shall remain stayed.
obligement.
May I please, your lordship? Here on 7/8/2025, the matter was referred to mediation, where opposite party number 2 agreed to pay the additional amount of 90,000. And pro forma opposite number 5 declined to provide any further enhancement at all. So lordship, accordingly, we filed an IA for striking out the name of the opposite party number 2 as they have paid the amount 90,000 rupees. Now, though the amount has been received by the tribunal, but the same has not been, disbursed by the tribunal, stating that they need an order from the Honorable High Court to release the money. And that too is sent by the registry. That order has to be sent by the registry.
Now, what is the status of this MAC appeal?
Lordship, we submitted the amended cost title after striking.
Who has agreed to pay?
Lordship, respondent number 2, New India, we have agreed to pay and we have already paid.
Yes, Lordship.
And on the last occasion, we were stuck up from the MAC appeal also.
Then whether appeal survives?
Service against respondent number 5.
But 5.
National
National.
There's 2 instances lawsuit. There's specific order, the appeal will continue against respondent number 5.
Okay. Heard, Miss, what is your name?
Chandan.
S. S.
Chanda on behalf of Mr. S. Vishwas.
Heard, Miss S. Chanda, appearing on behalf of Mr. S. C. Vishwas, learned counsel for the appellant. Mr. A. Acharya, respondent number 2 has already been struck out. So you are not there.
I'm not there and our name should be removed from the false list also.
Mr. S. A. Acharya, learned counsel for the appellant, learned counsel for the respondent number 2 submits that the name of respondent number 2 has already been strike out from the memo of appeal by order dated 1/12/2025 passed by this court. However, their names are continued to be shown in the cause list. Hence, he prays for a direction to the registry not to show the name of Mr. A. Acharya and Miss B. Acharya in the cause list henceforth. Stop registry to do so. It also appears that in pursuant to the amicable settlement arrived at between the appellant and respondent number 2, the respondent number 2 has already deposited an amount of rupees
90,000
90,000
as a full and final settlement.
as full and final settlement against this said respondent. Full and final settlement of the claim against the said respondent. However, she submits that the money is not yet disbursed to the claimant by the concerned motor accident claims tribunal. Stop. The concerned motor accident claims tribunal shall disburse the money deposited by respondent number 2 in terms of directions of this court to the respondent to the claimant. How many claimants are there? Only one.
Only one Lordship.
To the claimant.
Srimati Kuldeep Mehra Lordship.
To the claimant after proper verification. Stop. Also, Miss P. Hujuri, the learned counsel for
5.
respondent number 5. What happened to other respondents? 4.
5 for 5. 3 for ADAS.
You have not taken steps against this respondent number 4.
We have taken Lordship.
When? On 16/11/22, you were directed to take steps, but you have not taken steps. It appears from record that the appellant was directed to take steps for issuance of notice upon respondent number 4. However, there is no indication of compliance of the said direction in the record. Hence, the appellant is directed to take fresh steps for issuance of notice upon respondent number 4 by speed post as well as by usual mode within 7 days from the date of this order, returnable on 23rd September.
Public.
Wait, please. Here, Mullah, we are appearing for both 1 and 3, respondent number 1 and 3.
Sir, which is not completed upon respondent number 2, Lordship.
With regards to respondent number 2, Milord, it has been almost 5 or 6 times, Milord, it has not been received. Let it be, Milord, paper published, because it was also an ex parte order in the trial court also. Let it be paper published, Milord.
Trial court, who is respondent number 2?
Owner.
Owner. It will.
It was ex parte order.
Yes, it was ex parte.
Then we will waive the notice.
Yes, it can be.
What is order 41 rule 14(2)? Okay, you take fresh steps.
So substituted manner.
Yes. Heard Miss P. Hajuri, learned counsel for the appellant. Also heard Mr.
Says Ahmed.
S.S. Ahmed, learned counsel for respondent number 1 and 3. It appears from office note dated 14/7/2026 that notice issued to respondent number 2 has returned with postal endorsement incomplete address. Stop. In view of the above fact, the appellant is directed to take fresh steps for issuance of notice upon the respondent number 2 by substituted mode of publishing the said notice in a newspaper which is widely circulated in the last known address of the said respondent. The appellant shall take steps within 15 days. The date of appearance to be shown in the notice shall be 24th of September. Let this matter be listed thereafter.
Date may be fixed. No?
After 24th September,
Published.
No, please, Lordship. Lordship, as per mediation report dated 28/7/2026, Lordship, that is marked as Annexure 1A, Lordship. The matter is already settled in within the parties, Lordship, with the amount of rupees 45 lakhs.
who is appearing for the other side?
We are appearing in the mediation, Lordship, but today is the absent.
Who is the counsel?
J. Rahman, Lordship.
We'll see one more date. We'll fix it next week.
Just sorted next week.
Yes. Heard Mr. A. Kakuti, learned counsel for the appellant, who submits that this matter was referred to mediation by this court, and during the mediation process, the parties reached at an amicable settlement, and the insurance company agreed to settle this appeal at how much was
45 lakhs.
by paying a compensation amount of rupees 45 lakhs to full and final satisfaction. You are the appellant?
Lordship.
Then we'll dispose it off. You pay it.
Lordship.
Stop. Though none has appeared for the respondent side, this court has gone through the report of the mediators, which is annexed with the record as at flag A. On perusal of the report of the mediator, it appears that mediator dated 27/7/2026, it appears that the appellant insurance company has agreed to pay an amount of rupees 45 lakhs to the respondents as full and final amount. In view of the report of the mediators and the amicable settlement arrived at between the parties, this appeal is disposed of in terms of the amicable settlement arrived at between the parties. The appellant shall deposit. Where will you deposit? In the registry or
Registry, Lordship.
deposit the agreed amount of 45 lakhs before the registry of this court within a period of 4 weeks from the date of this order. On such deposit, the amount shall be disbursed to the claimants after proper verification.
Lordship, There is a prayer for withdraw the statutory amount of rupees 25.
The statutory amount deposited by the appellant at the time of filing of this appeal may be returned back to the appellant after proper verification. This appeal is accordingly disposed of.
Obliged.
21 and 22.
Watching item 21. ID card has not been received in respect of respond number 6 and 7. And for respond number 8, Lordship, answer notice has been received without any remark, Lordship. So for respond number 6, 7, and 8, I'd like to take steps, Lordship, through paper publication.
Heard Mr. S. Sharma, R. Sharma, learned counsel for the appellant.
My lord.
Also heard Mr. D. K. Kolita.
DK Kolita, so 1, 2, 3, lordship, but my name has not been shown, lordship. And
Respondent number 1, 2, and 3. On perusal of the office note dated 12/3/2026, it appears that the notices issued to respondent number 6, 7, and 8 have not been served. In view of the above, the appellant is allowed to take fresh steps for issuance of notice upon the respondent number 6, 7, and 8 by substituted mode of paper publication, by substituted mode of publishing the notice in newspaper, which is widely circulated in the last known address of the above mentioned respondents. The appellant shall take steps within 15 days from the date of this order. The date of appearance to be shown in the notice shall be 30 September. Let this matter be listed after the said date. The registry is directed to reflect the name of Mr. D. K. Kolita in the cause list as engaged counsel for respondent number 1, 2, and 3.
1, 2, 3.
Henceforth.
My lord, I have not received copy also, lordship.
Well, sir, the copy.
I have the-
Furnish.
Yes, lordship.
And 22.
Yes, lordship, I have filed a miscase, lordship, of the respondent number 1, lordship, that is the claimant, lordship. Because lordship, they have deposited the amount of rupees 1 lakh.
No, this appeal is by you.
No, lordship,
I have
and
filed
the
a
respondent, I
Yeah.
have.
They have filed an
miscase.
IA for release of the 50%.
Who has filed this appeal?
Claim, I've insurance company.
Two appeals.
Yes, Lordship.
Why they are connected?
Lordship, because they have they are filed by the two claimants, Lordship. One is the pillion rider and one is the driver.
Two separate
Two separate
claims cases,
separate person, Lordship.
but common judgment,
Common judgment, Lordship.
Not common, separate judgment.
separate judgment
Separate
Say,
judgment.
for say,
arising out of same
Yeah.
accident.
Yes, yes.
Okay.
and we have no objection, Lordship, that amount may be released.
In Mac appeal likhibo, heard Mr.
DK Kolita.
No. Heard Mr. R. Sharma, the learned counsel for the appellant. Also heard Mr. D. K. Kolita, the learned counsel for respondent number
1, lordship.
1.
1, lordship. And in this case also, my name has been shown, lordship, and the main
One.
appeal, lordship.
On perusal of the office note dated 1/4/2026, it appears that the notice issued to
Unserved notice has been received, Lordship, for respondent 1 and 2.
respondent number 2, 3, and 4 have not been served. You take fresh steps.
Through paper publication, Lordship.
Yes. The appellant is allowed to take fresh steps by issuance of notice upon respondent number 2, 3, and 4 by publishing the said notices in newspaper which is widely circulated in the last known addresses of the above mentioned respondents. The appellant shall take steps within 7 days within 15 days from the date of this order, 15 days from the date of this order, stop. The date of appearance to be shown in the said notice shall be
30 September. Lord.
30 September. List this matter thereafter. The registry shall reflect the name of Mr. D.K. Kolita in the cause list as engaged counsel for respondent number 1 henceforth. IA. Heard Mr. D.K. Kolita, learned counsel for the applicant. Also heard Mr. R. Sharma, learned counsel for the respondent insurance company. Stop. This interlocutory application has been filed by the applicant slash claimant. How many claimants are there?
One claimant, Lordship. In the
Claimant praying for allowing the claimant to withdraw the, it is 50%.
50%.
The 50% of the awarded amount which was deposited by the insurance company before the registry of this court in compliance to order dated 27/8/2025 passed in IA within bracket civil number 2780/2025. The learned counsel for the insurance company does not raise any objection to the said prayer. Hence the prayer is allowed. The registry is directed to disburse the amount deposited by the insurance company within bracket rupees 1,50,737 in pursuant to the directions of this court, comma, to the present applicant slash claimant after proper verification. This interlocutory application is accordingly disposed of.
My Lordship.
Yes,
So in this case, there is 170 days delay in filing the appeal, Lordship.
opposing.
Objection, Lordship. In fact, talk of settlement is going on. It's almost final, Lordship.
Okay. Heard Mr. K.K. Bhatto, the learned counsel for the applicant. Also heard Mr. M. Talukdar, the learned counsel for the opposite party's claimant, as well as Miss M. Chaudhary, appearing for opposite party number 3. This interlocutory application has been filed by the applicant insurance company, praying for condonation of delay of 117 days in preferring the connected MAC appeal. Stop. The learned counsel for the applicant has submitted that the applicant has stated the reasons for delay in paragraph number
4 and 5.
4 and 5 of the said of the instant application. Stop. On the other hand, Mr. M. Talukdar, learned counsel for the opposite party claimant, submits that he does not have any objection in condoning the delay as prayed for by the applicant. He submits that there is a likelihood of the parties arriving at an amicable settlement as a talk of compromise is going on between them. Ms. M. Chaudhary also does not raise any objection. Stop. I have considered the submissions made by learned counsel for both sides. Stop. After considering the grounds stated in the instant interlocutory applications to be sufficient cause which prevented the applicant in approaching this court within prescribed period of limitation in filing the connected appeal, as well as considering the fact that a talk of compromise is going on between the parties, comma, the delay of 117 days in preferring the connected appeal is hereby condoned and this interlocutory application is allowed. The registry shall register the connected MAC appeal and list the same for admission after a week on a date to
Next
be-
week, Lordship,
in the next week.
and showing my name for respondent
Then-
number one.
The name of Mr. M. Talukdar may be shown in the cause list for respondent number
One.
1. Stop. The name of Miss M. Chaudhary may also be shown in the cause list as engaged counsel for respondent number 3.
May I please your lordship? This IA is for substitution of legal representative.
You have any objection?
Yes, we'll file a reply, your lordship, in this case. I'm for representing respondent number 1 and 2.
And 3?
Lordship, 3 awaits, postal track consignment is there, but no one is appealing for 3.
Heard Mr.
J.A. Sigdar.
J. A. Sigdar, learned counsel for the applicant. Also heard Mr. R. K.
Singh,
Seal,
SINGH.
R. K. Singh, the learned counsel for respondent number 1 and 3. On perusal of the office note, where is the post? Flag is house, miscellaneous flag. Postal track consignment report code. Okay, assess. On perusal of the office note dated 18/8/2026, it appears that from postal track consignment report of the notice issued to respondent number 3, it appears that the said notice was delivered to the addressee on 4/7/2026. Stop. As such, comma, the notice issued to respondent number 3 is held to be duly served. Stop. The learned counsel for respondent number Jagat opposite party. Opposite party number 1 and 2 has prayed for some time for filing written objection in this case. The prayer is allowed. Let this matter be listed on 16th of September.
Lordship, here in this case, I am applying for the sole respondent. Here the service is complete. So I pray the matter may be taken up for hearing on any day as your lordship desires.
What is the issue?
Issue my lord, they filed an application before the executing court under Order 9 Rule 13 to set aside the ex parte decree with a delay continuation application. That application was rejected. Against that, they have come before this court.
I'm praying,
Now,
Yes, you are praying for.
continue to interim till the next date.
There is an interim is there.
Yes, yes. My execution case is pending. ma'am. One
Last week,
execution.
they say that they will file an objection in the state.
No, we'll decide the appeal,
Yes, that will. be
main
better.
appeal.
Yes, ma'am.
Wait. Heard. Miss, what is her name?
On behalf of the
M. Burman. the learned counsel appearing on behalf of Mr. D. Nath, the learned senior government counsel appearing for the FO. Appearing for the appellant. Also, Mr. G. Bhardwaj appearing for the sole respondent. Whether records would be necessary.
Everything is in its authority.
It is submitted at bar that requisitioning of trial court records may not be necessary, as all relevant documents are annexed in the as all relevant documents are there on record. As such, let this matter be listed for hearing on after puja,
Date may be fixed, my
For
lordship.
puja will be better.
before puja at the end. 15th of October.
Interim-
The interim order granted in the connected interlocutory application shall continue till next day.
Lordship, in this case, as directed by this honorable court, I have taken steps upon respondent number 4. For Lordship sees order, office note dated 18/8.
For no service.
No service. Service may be awaited.
When have you taken steps? Okay, okay. We'll ask them to
Yes, on last.
postal track consignment. Heard Mr. G. Bhardwaj, the learned counsel for the applicant. Also heard Mr. D. Chakravarti, the learned counsel for the opposite party number 1, as well as Mr. R. J. Das, appearing for opposite party number 3, and Miss M. Kolita, appearing for opposite party number 7, 8, 9, and 10. On perusal of the office note, it appears that the service report in respect of notices issued to respond opposite party number 4 is awaited. Stop. Next para. The registry is directed to place the postal track consignment report of the notice issued to opposite party number 4 by speed post before this court on the next date fixed. Let this matter be listed 9th of September.
May I please, Your Lordship? Lordship, I peruse order dated 18/12/2025.
Yes.
My lord, by order dated 28/2025, the Lordship had directed the insurance company to pay an amount of rupees 10 lakhs and odd to the applicant.
Which order?
By order dated, my lord, 28/2025.
28 or 18?
I'm
18 paid.
18/12/2025, Your Lordship is perusing the order in the
Yeah.
IA, my lord.
Yes.
My lord, by this order, the insurance company was directed to place the calculation by which they made the payment to the applicants, my lord. We have made a calculation, and according to us, there is shortage of rupees 3 lakhs as on the date on which they had made us the payment of compensation. So they were supposed to place the calculation today.
Why this I is filed?
For compliance of the order passed by this honorable court.
The MSC case has been disposed
Disposed
of.
of.
Okay. Yes.
Lordships, as per this honorable court's order, we have satisfied the amount and the matter is already disposed of, and now they have filed this IA for compliance of the final order.
No, but you go to the 18/12/2025 order.
Last order.
Lordships, 1 week time may be given, I will file it.
Let them file a calculation by way of an affidavit, so that we can also respond.
Heard Mr. B. Prasad, the learned counsel for the applicants. Also heard Mr. N. M. Datta, the learned counsel for opposite party number 1/insurance company, who seeks a week's time to file an affidavit indicating therein regarding as to whether any outstanding dues are there to be paid to the claimants in terms of the directions of this court, and if so, the details thereof. Let this matter be listed when 9th of September.
Obliged.
May please your lordship. So as per direction of the honorable court, we have take steps for proper publication upon respondent number 1, lordship, and file our affidavit.
When it was published in newspaper, when
10/6, lordship.
what was the date mentioned in the
Lordship.
what was the date mentioned in the notice for appearance?
15/7, lordship.
Heard Ms. P. Hujuri, the learned counsel for the appellant, submits that
My lord. My lord, I am not audible from your side, my lord.
Yes, Mr. Das.
Yes, my lord. My lord, item number 30, review petition number 52/26, my lord. Notice to the respondent is sent, my lord. Notice to the respondent number 1 is already received, my lord. Regarding the notice to the respondent number 2 and 3, still awaited for the service report, my lord.
Now, what is your submission?
My submission regarding the review petition, my lord.
Regarding the notice,
Regarding notice, my lord, fresh steps may be taken up by registered post only, my lord.
heard Mr. B.R. Das, the learned counsel for review petitioner. On perusal of the office note dated 25/6/2026, it appears that notice issued to the AD card issued along with the notice, AD card sent along with the notice issued to respondent number 1 has returned with the seal of the insurance company there. As such, the notice issued to respondent number 1 is held to be duly served. Stop. As regards respondent number 2 and 3, the service report is still awaited. The petitioner is directed to take fresh steps for issuance of notice by speed post within 7 days from the date of this order, returnable on
7-9,
20
my lord. 7-9.
returnable on
Yes. 7-9. Can it be fixed on 7-9, my lord?
23rd September.
My lord, 23rd September, I will be not available. Can it be fixed?
That is your problem.
Okay, my lord.
May I please, Lordship?
Yes.
I beg to mention item 20. It is already over, Lordship. I beg your apology, Lordship.
What happened?
I am for the respondent number 1 to 3. Also, it is settled case. It is settled before the mediator. And what is happened? The trial court has awarded a sum of.
The order, you see. It has been disposed of.
It has been disposed of. But what is happened, Lordship? It is settled before the mediator, and it is the settled amount is 45 lakhs. And at the time of the trial, the learned tribunal has awarded a sum of rupees 96 lakhs as a compensation, out of which 50 lakhs is fixed. Now it is, Your Honor, we have settled at the sum of rupees 45 lakhs. Therefore, if the fixed amount is not clear, Lordship, it will create confusion before the learned tribunal. Lordship.
Fixed amount means?
Fixed amount, at the time of the passing the award, the learned tribunal has fixed a sum of rupees 50 lakhs as a fixed deposit.
No, that goes because now the matter has been settled at 45 lakhs.
45 lakhs. And it is not clear, Lordship, whether which person will be fixed or which person will be open.
Okay.
Yes, well, Lordship.
You are claimant.
Yes, Lordship. I am for the claimant.
What is your submission? Yes, Mr. Kakoti. There will be no fixed deposit.
Also, there's a three claimants in their Lordship. One is the wife of the deceased, and another one is the minor son of the deceased, Lordship. And another one is the mother of the deceased.
Total Amitabh Kobo 20. How much was fixed?
At the time of award, Your Honor, the Lordship, the 50 lakhs is fixed in the name of the three claimants. And now the settled amount is 45 lakhs. Therefore, in proportion, Your Honor.
Where were you when the matter was called?
Oh, Lordship, I am in the another court, Lordship. Yes, I apologize, Lordship.
Now, what is your submission? How much should be fixed?
At least, Your Honor, half of the amount may be fixed, Your Honor, and half of the amount may be open,
20 lakhs will be fixed
Lordship.
and
It will
25,
start this.
25 lakhs will be disbursed. Amitabh koi thobo. I will change it. 20 lakhs fixed in the name of claimants.
3 claimants.
25 lakhs may be disposed of.
Highly honorable, Lordship.
May I please, Malok? Current MSc appeal is related with another MSc appeal that is 405 of 2026. So we pray for the matters to be tagged along and a new date may be given.
My lord, my IA may be considered, my lord.
I'm appearing on behalf of Mr. M. Sarania.
My lord,
Yes, my lord, we have filed our objections. On the next date, it may be considered, my lord.
my lord, they have time several
I,
times.
along with for the state. So,
Heard Mr. P.P. Gogoi.
my lord, N. Gogoi,
N. Gogoi.
appearing on behalf of Mr. M. Sarania.
Appearing on behalf of Mr. M.
Yes, my
Saronia.
lord. His name is in the Vakalat now.
M. Saronia, the learned counsel for the appellant, who submits that there is another MAC appeal arising out of same judgment which has been impugned in this appeal, namely MAC appeal number
405,
405/2026. He prays for the listing both the MAC appeals together. On the other hand, Mr. B.R. Das, the learned counsel for the respondent claimant, submits that there is an interlocutory application that is I-540/2026. Same may be taken up for consideration. So, as in the instant interlocutory, in the said interlocutory application, the present appellant has filed written objection and deems it proper to take it up after this appeal is listed along with the connected MAC appeal. So, as such, the registry is directed to list this MAC appeal along with MAC appeal number 405
405 of 2026.
of 2026 on 9th of September.
Can it fix, my lord, 7th of September?
On 7th of September.
Highly obliged.
Item 32 and 33.
My lord, notice to sole respondent is duly served, my lord.
Yes, what is your submission?
My lord, regarding the review, my lord, I wish to submit before this honorable court that my there is a delay condon petition for the delay of 994 days, and I had filed in one IA, right, IA number 2425/2021. My lord, that IA was dismissed on the date of 9/1/2026 due to lack of sufficient ground regarding the delay in respect of the filing the MSc appeal, my lord. My lord, grounds for the delay I have mentioned in the kindly see the grounds, page number 5 of my review application, my lord. I have uh, clearly mentioned, and I have also one two annexers regarding the payment of the trial court payment. My lord, the appellant was came to know about of the payment, about of the judgment of the trial court on 6/3/2018. My lord, that is after the 435 days. My lord, at the time of the argument, the claimant was not present before the court, so he was unaware about of the judgment on the date of 20.
No, Mr. Das.
My lord.
When are you appearing in person before this court?
My lord, I was appeared before this court, my lord.
No, when will you appear in person? Not through VC. On 7 September, are you coming to the court?
Yes, my lord. Yes, my lord.
Then we'll take it up on 7 September.
Okay, my lord. Highly applies.
Heard Mr. B.R. Das, learned counsel for the petitioner. On perusal of office note dated 13/7/2026, it appears that the notice issued to the sole respondent have been duly served. Stop. Let this matter be listed again on 7 September in orders column.
Highly applies.
May it please Your Honor. Your Lordship, as per office note dated 19/8/26.
Yes.
MAP for respondents.
How many respondents?
I'm
One, two.
Yes, what is the response?
My lord, I need some time to go through the entire records, as I have to obtain the certified copies of some civil cases of title suit number 240/2003.
No, the allegation is you have willfully violated the direction of the court.
Yes, my lord. So that I need some time to go through the entire records.
Now you go through, but you tell this court whether you have violated or not.
That
If
I
you have
have to take
violated,
the
we will
necessary-
send you to prison.
Then I have to take the necessary instruction from my client, whether they are in possession of the said property or not.
Lordship, I have annexed the photographs of the suit land as well, where the alleged violation has taken place.
You file affidavit
Yes.
after taking instruction.
Sheets and
Heard Miss V. Rai, the learned counsel for the petitioner. Also heard Mr.
Sanjay Kumar Sudhir.
S.K.
Yes, Chaudhary.
S.K. Chaudhary, appearing for the sole respondent / contemner, who submits that some time may be granted to him for taking necessary instructions and to file an affidavit in this case. The prayer is allowed. Let this matter be listed again on 25th of September.
Deeply obliged.
Item 35.
Yes.
Okay, respondent number 2 has appeared. And so far as respondent number 1 owner is concerned, the notice, as per office note, the notice was served upon the wife of this owner. That's maybe accepted because already wife, I think.
Heard Mr. D. Ullah, the learned counsel for the appellant. Also heard Ms. L. Sharma, the learned counsel for the respondent number 2. On perusal of the office note dated 19/8/2026, it appears that the notice issued to respondent number 1 has been served on the wife of the respondent number 1 by the process server. So in view of above, the notice issued to respondent number 1 is held to be duly served. The records of MAC case number, records of MAC case, concerned MAC case have been received. Hence, this appeal is ready for hearing. List this matter for hearing after 4 weeks. Date you may get in, we can fix date also in December. Date at the let this matter be listed.
Then Lordship,
After 4 weeks.
After 4 weeks.
After 4, after 6 weeks on a date to be fixed by registry.
Item 46.
Appeals your document. As per office note dated 19/8/2026, the respondent number 1 address could not be traced. And in the cause title, we have mentioned 2 addresses. We have taken steps upon the present address of the respondent number 1. We may take steps upon the respondent number 1 in the permanent address, which is mentioned in the cause title.
Not Mr. Ashar.
And there's another thing.
Yes.
Respondent number 2's postal remark, the notice upon respondent who has come back without any postal remark. And respondent number 3's notice is awaited.
So what is your submission as regards?
3 may be striked out.
No.
Is the
What is your
upon respondent number 2, we may take fresh steps
okay.
by way of speed post.
1 again fresh step.
1 and 2.
Heard Mr. S. Sharma, the learned counsel for the appellant. On perusal of the office note dated 19/8/2026, it appears that notice issued to respondent number 1 and 2 could not be served, whereas notice issued to respondent number 3, whereas service report in respect of notice issued to respondent number 3 is awaited. The registry is directed to place the postal track consignment report of notice issued to respondent number 3 by speed post before this court on the next date fixed. The appellant shall take fresh steps for issuance of notice upon respondent number 1 and 2 by speed post within 7 days from the date of this order, returnable on 23rd September.
Item 47.
Please, Lordship, as per office note dated 19/8/2026, service for the respondent number 1 and 2 is complete, Lordship, and service for the respondent number 3 is still awaited.
I'm appearing for 1 and 2.
Heard Mr. A. Kakoti, the learned counsel for the appellant. Also heard Mr. M. Khan, the learned counsel for respondent number 1 and 2. On perusal of the office note dated 19/8/2026, it appears that service report in respect of notice issued to respondent number 3 is awaited. Stop. The registry shall place the postal track consignment report of the notice issued to respondent number 3 by speed post before this court on the next date fixed. List this matter on 11th September. Into kuntu section hui. Superintendent number 3. Rita Pandra. Nalange any mati.
So there, then
Okay.
IA lordship.
What I
IA for-
Lordship, there's an IF for stay, but the IF may be disposed of after appearance of the respondent number 3. Lordship.
Lordship, there his appearance is not.
Because there is a
present.
violation
Claimants
of
are-
the policy
their
condition,
claimant
Lordship,
lordship
there's an
already appear lordship 50%.
one by one. If you
But already we appear for the claimant lordship, that 50% may be considered lordship. And then stay may be granted.
we'll take up the IA on the next date. Next date is on 11th September. We'll take it. IA same order. Same order. Common order.
Item 38.
Item 38 lordship. 1 and 2 has appeared, 3 is waited lordship. Trade consignment of the speed post may be lordship.
Heard Mr. M. Khan, the learned counsel for the appellant. Also heard Mr. R.C. Paul, the learned counsel appearing for respondent number
1 and 2.
1 and 2. On perusal of the office note, it appears office note dated 19/8/2026. It appears that the postal track consignment, it appears that the service report in respect of notice issued to respondent number 3 is awaited. The registry shall place the postal track consignment report of notice issued to respondent number 3 by speed post on the next date fixed, 11th September.
39 is same. Same order.
39
Analogous.
same order. Superintendent যেটা মাতিব এই রেকর্ড তো মধ্যে
Similar order.
same order.
Item 40.
Yes.
Lordship, as per office note dated 19/8/26, AD card for respondent R3 is still awaited.
I am appearing as respondent 3, madam.
There are 3 only. Heard Miss D. Hajorika, the learned counsel for the appellant. Also Miss
J. Bush on behalf of Mr. N.C. Das, Senior Counsel.
Also Mr. J. Basho, appearing on behalf of Mr. N.C. Das, learned counsel for respondent number 1, as well as Mr. R. Mandal, appearing for respondent number 2, as well as Mr. N. Burra, appearing for respondent number 3. The trial court record is. It appears that appearance of parties in this appeal is complete. However, the record of concern, my MAC case, that is MAC within bracket death case number 61/2022, have not yet been received. Stop registry to issue a reminder for the same. Place this matter again after receipt of the trial court records on 18th of September.
Item 41.
May it please your lordship. Madam, IA is for madam condemnation of delay, madam. Delay is only 18 days delay is there.
You're opposing. Heard Mr. B.K. Das.
HP Gwala.
Sorry, H.P. Gwala, learned counsel for the applicant. Also heard Ms. P. Chakravarti, the learned counsel appearing for opposite party. This interlocutory application has been filed by the applicant Shri Boli Narayan Gogoi under Section 5 of the Limitation Act, praying for condonation of delay of 18 days in preferring the connected MAC appeal, wherein the judgment and order dated 9/1/2026 passed by the London District Judge Dibrugarh in title suit within bracket D number 114/2024 is impugned. Whether divorce was granted or rejected?
Rejected.
Rejected. No.
Paragraph 5 is the explanation.
The learned counsel for the petitioner has submitted that the reasons for approaching this court belatedly has been stated in paragraph 5 of the instant interlocutory application. Stop. The learned counsel for the respondent submits that she does not have any objection if the delay of 18 days is condoned by this court. Stop. I have considered.
8/26, notice has been served to respondent to lordship.
Lordship, I am paying for respondent number 1 in this matter, Lordship.
Who is for 2?
The insurance company, Lordship.
You are claimant or
Lordship, I
owner?
am owner of the vehicle.
You have any objection?
No, Lord.
Heard. Mr. What is your name?
R. Kumar.
R. Kumar, the learned counsel for the applicant. Also heard Mr. K. Jain, learned counsel for opposite party number 1. On perusal of the office note dated 18/8/2026, it appears that notice issued to opposite party number 2 has been received by an employee of the respondent opposite party 2 insurance company. Hence, the notice issued to said opposite party is held to be duly served. Now, this interlocutory application has been filed by the applicant under Section 5 of the Limitation Act 1963, praying for condonation of delay of 85 days in preferring the connected MAC appeal, wherein the judgment and order dated 10/12/2025 passed by the Motor Accident Claims Tribunal, come Additional District Judge FTC Durham in MAC case within bracket I number 92/2018 has been impugned. The learned counsel for the applicant has submitted that the grounds for delay has been stated in paragraph number
Paragraph 3, Lordship.
3 of the instant interlocutory application. Stop. On the other hand, Mr. K. Jain, learned counsel for the respondent number 1 has opposite party number 1 has raised no objection against the prayer of condoning the delay. I have considered the submissions made by learned counsel for both sides and have gone through the materials on record. After considering the grounds stated in paragraph number 3 of the instant interlocutory application, this court is of opinion that same may be regarded as sufficient cause which prevented the applicant in preferring the connected appeal within the prescribed period of limitation. As such, the delay of 85 days in preferring the connected MAC appeal is hereby condoned, and this interlocutory application is allowed. The registry is directed to register the connected MAC appeal and list the same for admission after a week on a date to be fixed by.
Much obliged.
Much obliged.
Item 44.
May I please be lordship?
Yes.
May I please be lordship? Lordship, according to office note dated 18/8/26, unserved notice of respondent number 2 has returned. And AD card of R1 and R3 has not returned, so postal tracking may be required, lordship.
Heard Mr. A. Agarwal, the learned counsel for the applicant. On perusal of the office note dated
18/8/26.
18/8/2026, it appears that the service report in respect of notice issued to opposite parties number 1 and 3 is awaited, whereas notice issued to respondent opposite party number 2 has returned without service. As such, comma, the registry is directed to place the postal track consignment report of notices issued to opposite party number 1 and 3 before this court on the next date fixed. The applicant is also
Fresh steps.
directed to take fresh steps for issuance of notice upon opposite party number 2 by speed post as well as by usual mode within 7 days from the date of this order, returnable on 23rd September.
Item 45.
Lordship, identical order.
Same, you have gone through.
Yes.
Same order.
Item 46.
Deeply ordered.
Yes.
With the delay.
Four days or
24.
24 days delay, lordship.
Heard Miss D. Hajorika, the learned counsel for the applicant. Also heard Mr. M. Khan, the learned counsel appearing for opposite party number
1 to 5.
1 to 5. 1 to 5. As well as Miss P. Talukdar appearing for opposite party number 6 and 7. Do you have any objection? This interlocutory application has been filed by the applicant insurance company under Section 5 of the Limitation Act 1963, praying for condonation of delay of 24 days in preferring the connected MAC appeal, wherein the judgment and award dated 5/2/2026 passed by the Motor Accident Claims Tribunal, Bongaigaon, in MSC case number 303/22 has been impugned. Stop. The learned counsel for the applicant submits that the grounds for delay has been stated in paragraph number. Which para?
Lordship, I'm not totally aware.
Why are you not aware?
Lordship, the file is actually not with me today.
You could have gone through the records of the court. Have been stated in paragraph number 4, 5 and 6 of the instant interlocutory application. On the other hand, learned counsel for the opposite parties have submitted that they do not have any objection if the delay of 24 days is condoned. Stop. After considering the submissions made by learned counsel for the parties as well as going through the records, this court is of considered opinion that the grounds stated in the instant interlocutory application by the applicant appears to be sufficient cause which prevented the applicants in preferring the connected appeal within the prescribed period of limitation. Stop. As such, the delay of 24 days in preferring the connected appeal is hereby condoned and this interlocutory application is allowed. The registry is directed to register the connected appeal and list the same for admission after a week on a date to be fixed by it.
They may be reflected in the legislation.
Name of Mr. M. Khan and Miss P. Talukdar as well as Mr. K.R. Padgiri may be reflected in the cause list as engaged counsel for the respondents.
He may be directed to appeal memo also.
You furnish the appeal memo to both the counsel.
Item 47.
Yes, my lordship, as per office note dated 18/8/26, the AD card or the answered notice of respondents has not yet arrived.
Third, Miss M. Setia, learned counsel for the applicant. On perusal of the office note dated 18/8/2026, it appears that service report in respect of notices issued to the respondents is awaited. The registry is directed to place the postal track consignment report of notices issued to the respondent opposite parties by speed post before this court on the next date fixed. Place this matter 11 September.
48.
May please, your lordships. This IA has been filed by the claimant respondent number 126 for early hearing of the MSc appeal, your lordships, filed by the applicant respondent, your lordships, appellant respondent. Since the dishonorable court by an order dated 21/2/2025 has admitted the appeal.
Yes.
Yes, and by the order dated 13/2/2026, the order which I have annexed before this in the appeal, your lordships, application, your lordships, page 14, annexure A. This honorable court by the order dated 13/2/2026 has directed to list the matter for hearing in the usual process. Your lordships, since the claimant, the petitioner,
Date. Hearing date. Come on. 1st December.
Lordship, can be already 3 years has been gone by, and the petitioners are.
But there are a lot of MSc appeal pending in the queue.
In the
We are giving a fixed date.
Can your lordships, can he on November or October last part, can be last part after we lordship 17 number.
Mr. H. Verwa, the learned counsel for the applicant in IA number 2558/26. Also, Ms. P. Hujuri, the learned counsel for opposite party number appellant, opposite party / appellant. This interlocutory application has been filed by the applicant / claimants praying for expeditious hearing of the connected appeal number 41/2025. The prayer is not opposed to by the learned counsel for the opposite party, hence same is allowed. Let the connected appeal be listed for final hearing on 17th of November. This interlocutory application is accordingly disposed of.
Lordship, deeply, Lordship.
49.
In appeal make order. In view of the order dated so and so passed in IA number so and so, let this appeal be listed for final hearing on 17th of November. Yes.
Please, Lordship. Lord, they filed an IA for withdrawal of the 50% which has been deposited before the registry. But in the main appeal, the service is complete. Just that the respondent number 3 has not appeared, and he's the driver of the pending vehicle. His name may be struck off, and the matter may be heard finally.
In this IA,
This IA is for withdrawal, considering it's an ex parte judgment, my lord. We filed a petition before the trial court that was rejected. We filed a petition for vacating the ex parte judgment that was rejected, and the judgment was passed without hearing us.
you did not appear, therefore it was
That
proceeded.
no proper notice was served. That's our plea.
In the meantime, IA may be allowed.
Respondent number 1 and 2 are duly served, and respondent number 3 names can be struck off and can be finally
No,
heard.
this IA will allow, subject to
Bond withdrawal of 50%.
subject
Which has been already
subject to
deposited.
payment furnishing of indemnity bond. What is your ground?
The main ground is that it's an ex parte judgment.
Notice was not served.
Notice was not properly served upon us.
And
And there
otherwise, on merit,
Otherwise,
on merit,
it can be withdrawn subject to bond, my lord.
heard Mr. Ayat Likhibo. What is your name?
Yes, Kathak laws.
S. Kathar,
Laws.
Kathak, K,
Yes,
Khak8,
TH.
H. Kathar, learned counsel for the applicant. Also heard Mr. S. Sharma, the learned counsel for the insurance company. This interlocutory application has been filed by the applicant claimant in connection with MAC appeal number 275/2026, praying for allowing the applicant claimant to withdraw the 50% of the awarded amount, which has been deposited by the opposite party / insurance company in compliance with the order dated 15/6/2026 passed by this court in IA within bracket civil number 1766/2026 in MAC appeal number 275/2026. The learned counsel for the insurance company has objected to the prayer on the ground that the connected appeal is ready for hearing and the impugned judgment was passed ex parte against the present against the insurance company. Stop. I have considered the submissions made by learned counsel for both the sides. After considering the entire aspects of this case, this court is inclined to allow this interlocutory application subject to certain conditions. The registry is directed to disburse the 50% of the money awarded amount which has been deposited by the insurance company in pursuant to the directions of this court as mentioned herein above to the applicant / claimant Srimati Ashavati Rohidas on furnishing an indemnity bond equivalent to the amount which is going to be which is to be disbursed to her in person to this order, comma, after proper verification. Stop. This interlocutory application is accordingly disposed of. Main appeal.
The respondent number 3 could not be traced out, my lord. His name will be struck off.
Heard Mr. S. Sharma, learned counsel for the appellant. Also heard Mr. Kathar, learned counsel for the respondent number 1. On perusal of the office note dated 3/8/2026, it appears that notice issued to this. You are appearing for only one.
Yes, sir. Respondent number 1.
Notice issued to respondent number 2 was duly served, whereas respondent number 3 could not be found in the given address. Learned counsel for the appellant has submitted that, considering the grounds stated in the memo of appeal by the present appellant, the presence of respondent number 3 may not be necessary for adjudicating this appeal. Hence, he prays for striking out the name of respondent number 3. The prayer is allowed. The trial court, the records of concerned MSC case have already been received. Hence, this appeal is ready for hearing. Place this matter for hearing after 4 weeks on a date to be fixed by registry.
May I please?
For the appellant, my lord. I think this matter has been wrongly posted in the order column also. It should have been in hearing also.
Hearing.
In the last order, it reflects that it was fixed for hearing also. LCR also received also.
Heard Mr. P.J. Burman, the learned counsel for the appellant. On perusal of the order dated 21/8/2024, it appears that the registry was directed to list this matter for hearing. However, it has been, somebody might have mentioned, it has been listed in orders column.
I was not informed.
Let this matter be listed for hearing after 4 weeks on a date to be fixed by registry.
Obliged.
May it please your lordship. Lordship, this is an appeal seeking enhancement of compensation by the claimant. Lordship, as per the last order, my lord, I was directed to take step upon respondent number 1 and 2, my lord, owner and driver of the offending truck, my lord.
Yes.
My lord, they may be, my lord, strike out, my lord, because, my lord, in the judgment also, my lord, the owner is having the, my lord, valid insurance policy, and the driver is also having valid driving license, my lord. So, my lord, they may be strike out, my lord.
Who is for 3?
3.
I'm for FI number 4.
For 3, my lord, Mr. A.N. Das.
No, 1, 2, 3 have appeared.
No, 1, 2,
3 have appeared.
3 and 4 appeared.
1 and 2, lordship, private is not complete.
Heard Mr. M. Datta, the learned counsel for the appellant. Also heard Ms. D. D. Burman, the learned counsel for respondent number 4. None has appeared for respondent number 3, though name of one engaged counsel for respondent number 3 is reflected in the cause list. The notice, the office note dated 28/2026 shows that the service report in respect of respondent number 1 and 2 is awaited. Sub-learned counsel for the appellant submits that considering the fact that this appeal is basically filed by the appellant on being aggrieved by the quantum of compensation awarded to him, the presence of respondent number 1 and 2 may not be necessary for proper adjudication of this appeal, hence he submits that their name may be strike out. Stop. Considering the submissions made by the learned counsel, the prayer is allowed. The names of respondent number 1 and 2 may be strike out from this memo of appeal.
FCI received, my lord.
The records of the MSC case number 48/2019 have been received from the concerned tribunal. Stop. Accordingly, let this matter be listed for hearing after 4 weeks on a date to be fixed by registry.
The date may be fixed, my lord.
Date the 1st of December.
Okay.
I have three.
Yes.
Actually, is appearing via online, actually.
Yes. You are not audible. You are not audible.
Lordship, am I
Yes.
audible now?
Yes.
Lordship, this revision has been preferred against the order passed by the Learned Civil Judge Junior Division number 4, whereby the Learned Trial Court ordered for implement of the principal respondent as one of the defendants in this suit. In a nutshell, regarding the history of the case, Lordship, the plaintiff instituted the suit for ejection of the persons who are licensee, and the suit has been proceeding against them, and at this stage of argument suddenly the present principal respondent filed an application under order 1 rule 10 CPC for his implement, stating that he is a tenant under the licenses. Our basic question has been that licensee himself is not having any title or interest to the property. How can a person claiming to be a tenant under the licensee can come into my suit? However, after hearing, the Learned Trial Court ordered for implement of the principal respondent, against which we have come before the Honorable Court for setting aside that order, because the plaintiff is always the
Where is the impugn order?
Lordship, page 35.
plaintiff is always the dominant litigant, lordship, and the plaintiff knows against whom he claims the relief. He has instituted the suit for relief of eviction against the persons who are unauthorizedly in occupation of the suit land. And in such circumstances, the respondent cannot come to the court and impose himself on the plaintiff to be added as a party and to claim that a claim should be made against him.
Yes.
We have my learned friend alongside me is Abhishek Bhattacharya. He will submit two judgments of the
No,
Apex
what
Court
was the
Lordship.
reasoning of the trial court while
Trial
implementing?
court that the documents submitted by him by the principal respondent with regard to the municipal trade license and electricity bills show that he is staying over there as having a shop, so he becomes a necessary party. Lordship, that cannot be a ground, because a municipal trade license and the electricity connection or the electricity payment bills are not documents of any title. These are also only ancillary documents.
No, whether principal respondent, that is respondent number 1, is in fact.
My lord,
Yes,
I am
yes,
there
yeah.
since a long time. I have electric connection. I am running a shop, my lord. My shop was closed.
But
Then-
he don't want your eviction.
My lord, this is not a petition, my lord. Under 227, your lordship will not intervene in such a order. How they will be prejudiced, my lord? Rather, it will facilitate. Nowadays, my lord, court also want to see, my lord, who is in possession.
No, no. He do not want to evict you.
My lord,
He-
if he says
he
so,
don't- he don't-
let him give an undertaking that he will not evict me. Because he put a lock on my property. Then, my lord, DC directed to open the same. That is fact statement mentioned in the order, in the order.
No, he's
My lord, how?
he's saying that.
Under 10 rule 2, my lord, Supreme Court also said, my lord, that there is a my lord, jurisdiction of the court, my lord. That judgment has been lied on.
Okay, let him finish his submission. Yes.
Lordship, if we refer to the affidavit in opposition filed by the principal defendant, they have mentioned rightly or wrongly he is in possession of the shop room. Rightly or wrongly, Lordship, can I be relegated to seek a decree against a person who is, even if he is present there without having any title and claiming to be a tenant of my licensee, to seek decree against him, whether he becomes a necessary party to the suit? The answer will always be in the negative, Lordship.
No, then
Because
how will you evict him if you don't get a decree against him when he's
because
saying that he's in possession?
yes, so when is according to him, his principal is my licensee. When my licensee is evicted, he is automatically evicted. There is no need for any separate decree against him. So he does not become necessary party. I have submitted judgments in that regards that will be supplied to
Which judgment?
supplied. Yes.
My lord, may see page 35, last 7 sentences.
No, let him complete. Let him complete. You have any other submission?
Yes, I have also given a written statement, written argument which will be submitted, Lordship. And and there is nothing to suggest even that the principal respondent herein is a necessary party to the suit. There are plethora of judgments, and this is settled position of law that if the decree against principal amounts to decree against the any person claiming under him. So as he is claiming under my licenses, decree against the licenses would amount to decree against him, and so he does not become an accessory party. He is not. He is absolutely a stranger to the suit, and his impediment is nowhere required. That is my submission, Lordship.
But you are not denying that he is in possession.
Yes, I am not denying, Lordship.
You agree that, you admit
Yes,
that.
yes, I agree that he is unlawfully there, and that can be agitated only during the execution proceeding. Order 21, Rule 97 is there. At this stage in a suit, he cannot come and impose upon himself himself on me.
No, what is the error in the impugned order?
Error in that the court did not analyze how he became an accessory party and did not at all ponder over that the plaintiff is not required to take any decree against him, against the principal respondent. That is the settled position of law. That settled position of law has been completely ignored by the learned trial.
Yes.
Lordship, only one point. Having the copy of the order, Lordship, page 41, the last paragraph. Coming back to a present petition, 807 filed by the petitioner for impleading in the impugned judgment only basis on the trade license and electricity bill. Lordship, he has been directed to be made a party. Page 41, last paragraph, Lordship. Only on basis of the electricity bill and the trade license, Lordship. He is given that he should be made a party. And this petition was filed when the matter was fixed for judgment, Lordship. Argument was over.
Our argument is, Lordship, that he does not come within the meaning of necessary party.
Okay. The rulings which you have cited.
Yes, yes.
Which paragraph you are relying? You have mentioned the paragraphs.
Yes, yes, yes. We have highlighted those.
Lordship, in the civil appeal 5918 of 2012, Lordship. Vidur Impacts Trader Private Limited versus Ghosh Apartment Private Limited.
Para 26
and 27, Lordship.
And in other case?
Lordship, other case, Lordship, have to take inside. I'll just mark it, Lordship.
You mark it.
Lordship.
We'll hear you at 2. At 2, we'll continue.
Lordship, I have a judgment in quota 25-2. To the late, Lordship.
Okay, we'll take it up at 2:10.
Well,
yes, Mr. Sharma, you have anything?
My lord, item number 4, my lord, the next item, my lord. My lord, the other side was to reply to the question of maintainability. My lord, but
next week.
They want it next week, and my lord, interim order has to be extended.
Item number 4.
It is for admission, my lord.
On request of Mr. What is your name? AHMR Chaudhary. This matter is on request of Mr. AHMR Chaudhary, Learned Counsel for respondent, which is not opposed to by Learned Senior Counsel for the petitioner. This matter may be listed on
2nd of September, my 2nd of September.
2nd of September. 2nd of September. Yes. Show the name of Mr. A.K. Bhattacharya and Mr. R. Sharma. 2nd September.
And my lord,
the interim order shall continue till next day.
Obliged, my lord.
Yes.
Item number 7. In this case, Roshan Raj was the senior advocate. And due to waterlogging, he has not come. The matter may be taken up next week, Wednesday.
Lord Mr. A.M. Ahmed, Learned Counsel for the 28. Petitioner,
20.
who seeks an adjournment due to personal difficulty of conducting counsel. Mr. A.R. Sigdar, learned counsel for the respondent, does not oppose the prayer. Let this matter be listed. Date due. After? After 2 weeks.
My lord, on
7th of September.
7 of September.
Yes, Mr. Kolita.
Hearing matter. This court will write little bit earlier, Lordship. Item 50, Lordship, hearing matter.
Yes. What is your prayer?
Lordship, take up any other day if possible.
You have informed the other side. On request from Mr. J. Kolita, learned counsel for the appellant, this matter is adjourned for a week. Listed after. We may continue. You can start your submission.
hello, I think your facts may be seen, my lord, at the first order, my lord. 34, 5.
Yes.
Second para. The brief of the petitioner. The petitioner is the proprietor of the underway retail outlet of electronic goods situated at Janigan Silchar, and the petitioner has been running his business of electronic goods under the name and style as underway since 2000. As a rented room situated in Janigan, which he took on monthly rental basis from different number 1, which is covered by holding number so and so, ward number 6, Silchar municipality. The defendant number 1 inducted the petitioner in the tenanted premises, which is part and parcel of the suit length, by executing rent agreement in favor of the petitioner, and such agreement was renewed from time to time, and the last renewal was done by tenancy agreement dated 25/1/14. But as the defendant number 1, a monthly rent rupees 1,000 per month, but as the defendant number 1 suddenly stopped accepting the monthly rent from the petitioner, he has been compelled to deposit the rent in court, and the petitioner has been depositing the rent in court regularly by filing rent control cases. The petitioner also, at his own cost and expenses, obtained electric connection to the tenanted premises and has been paying the monthly electric consumption charges to the PDCL regularly, punctually. In the year 2018, the defendant number 1, with the intention of ousting the petitioner from the tenanted premises, abruptly closed down the shop by locking up the same, and the petitioner was compelled to.
Who is defendant number 1?
Defendant number 1, my lord.
Not the petitioner, present.
Not the petitioner. Defendant number 1 from whom I have taken the rent.
Okay. Okay.
I have taken the house on that. With the intention of ousting the petitioner from the tenanted premises, abruptly closed down the shop by locking the same, and the petitioner was compelled to report the matter to DDC. And
So there is a dispute between you and your subletter also.
Yes, my lord.
And there is a dispute between them also.
Not only them, my lord, because the plaintiff, my lord, who had purchased later, my lord, he wanted to a big, my lord, in collision of that. That comes here. Compelled to report the matter to DDC and Magistrate Kachar, Silchar, hide order later passed in order opening of the lock of the said shop, thereby allowing the petitioner to continue his business in the said shop. It seems that the plaintiff and the defendants have deliberately suppressed the fact of disposition of a part of the suit premises by the petitioner since long, and the suit was instituted in collision with the defendants with a malified intention to wrongfully grab the shop premises of the petitioner. The petitioner has a valuable interest in the suit. So this is the question, my lord. In the property and the necessary party to the suit without impleading him, the instant suit cannot proceed, and the petitioner is required to be added as a defendant in the instant suit for complete and effective adjudication of the instant suit, and also to protect the interest of petitioner over the suit property. And if the petitioner is not added, the defendant will lead multiplicity of suit and the proceeding, and the petitioner will suffer for loss. But this is a fact, my lord. In such a case, my lord, the learned trial court has allowed to implead me, my lord. I have relied on the judgment of the 2010 1 SCC, my lord. That is very clear, my lord. In such facts, my lord, this honorable court will not interfere under 227, my lord, until others, my lord, there is gross injustice, my lord. Yes. And absolutely without jurisdiction. Here, no injustice has been caused to them, my lord. Because otherwise, they have said that they are in possession. That is the, my lord, their position, defendant, entire position with plaintiff. And they wanted to evict me. That is the question. That is like, this is not a case, my lord, where your lordship is that. That has been, my lord, considered by this one.
Which judgment you are relying?
My lord, 2010, 7 SCC I have given us. 417.
Which?
Paragraph 13 to 15 and 20 to 23. This was relied on by trial court also, madam. The general rule in regard to implement of party is that the plaintiff in the suit, being dominant litigant, may choose the person against whom he wishes to litigate and cannot be compelled to sue the person against whom does not seek relief. Consequently, a person who is not a party has right to be impleaded against the wishes of the plaintiff. But this general rule is subject to the provisions of Order 1, Rule 10 of the Code of Civil Procedure, which provides for implement of the proper and necessary parties. The said sub-rule is quoted, madam. Your lordship said, no, madam, I'm not reading it. The said provision makes it clear that court may at any stage of the proceeding, including suits for specific purpose, either upon or even without any application, and on such terms as may appear to it to be just and direct, that any of the following persons may be added as a party. Any person who ought to have been joined as plaintiff or defendant, but not added, and any person whose presence before the court may be necessary in order to enable the court to effectively and completely adjudicate upon the upon and settle the question involved in the suit. In short, the court is given the discretion to add a party, any person who is found to be necessary party or proper party. A necessary party is a person who ought to have been joined as a party and whose presence no effective decree could be passed at all by the court. Well, this is very important, my lord, because I am in possession. If a necessary party is not impleaded, the suit itself is liable to be dismissed. A proper party is a party who though not a necessary party, is a person whose presence would be enabled the court to completely and effectively and adequately adjudicate upon the matter, all matters in dispute in the suit. Though he need not be a person in favor of or against whom that decree is to be made. If a person is not found to be proper or necessary party, the court may not show jurisdiction to implead him against the wishes of the plaintiff. The fact that a person is likely to secure a right interest in the suit property after a suit is decided against a plaintiff, who will not make such person as a party or a proper party in the suit for his free purpose. But that is free. Now 22, 23. Let us consider the scope and ambit of Order 1, Rule 10.2 regarding strikeout any party. They say sub-rule is not about the right of a non-party to be impleaded as a party, but about the judicial discretion of the court to strike out or add parties at any stage of the proceeding. The discretion under sub-rule can be exercised either suo motu or on application of the plaintiff or the defendant, or an application by a person who is not a party to the suit. The court can strike out any party who is improperly joined. The court can add anyone as a plaintiff or a defendant if he finds that he is necessary party or a proper party. Such deletion or addition can be without any condition or subject to such term as the court may deem fit to impose. In exercising its judicial discretion under Order 1, Rule 10, the court will, of course, act according to the reason and fair play, and not according to the whim circumstances. This court in so-and-so, the definition of discretion by the so-and-so, when applied to a court, the justice means sound discretion guided by law. It must be run by, not by human, but it must be arbitrary, archaic, sensible, or such. My lord, here, my lord, just reason, my lord, he cannot be evicted, my lord, without impeding him, because he is in possession of, but they said that they are in possession. Then why is this suit is there? So this is the matter, because defendant and plaintiff collided with each other, and they wanted to evict the plaintiff. So, my lord, I don't think, my lord, that this is a case where your lordship will exercise the power under Article 227.
Yes, you want to say anything?
Yes, Lordship. Lordship, the entire discussion boils down to whether he is a necessary party. And for this reason, Lordship, apart from at this stage,
He is not a necessary party. Assuming that he is not a necessary party, but if court comes to a conclusion that he is a proper party, then was the trial court wrong in pleading him?
that is why Lordship on the submission made by my learned counsel for the other side, completely forgetting that the 73 amendment has brought in a new chapter, that is order 21 rule 97 onwards up to order 21 rule 106. Any third party who is claiming only possession, his rights will be determined according to order 21 rule 97 or 99 and not in the suit at the execution proceeding. If he is afraid of that he will lose his position, I need not have any decree. I can resort to, as plaintiff, I can that at that stage as decree that I can resort to order 21 to 97, and the third party can resort to order 21 to 99. But so far as this suit is concerned, he is neither a necessary party nor a proper party, because he is not claiming any right title interest over the suit property. His only contention is that he is in possession of the same, and that too by his own admission, rightly or wrongly, that he is in possession. That on the basis of his position, if he wants to resist delivery of possession, his resort is order 21 rule 97 at the stage of execution, and not by getting implemented in this suit. That is why the CPC was amended, and the entire chapter from order 21 rule 97 to 106 for determination of the third party rights or the third party possession, that new provisions have been created. That would be in the execution, not during the stage of the trial, Lordship.
Third, Mr. S. Chaudhary, the learned counsel for the petitioner. Also heard Mr. G. N. Sahewala, the learned senior counsel, assisted by Ms. S. Todi, the learned counsel for the respondent number
1.
Respondent number 1. And who is appearing for other respondent?
Nobody appears, my lord, because they are actually plenty. Own person.
Respondent number 1. This application under Article 227 of the Constitution of India has been filed by the petitioner applicant, by the petitioner Srimati Kimi Sharda, impugning the order dated 10/9/2024 passed by the Court of London, Civil Judge, Junior Division, number 4, Kachar, Silchar, in Ms. J case number 102/2023, whereby the prayer for impleading the respondent number 1 as a defendant in the title suit number
130 of 2021.
138/2021 was allowed. and the petitioner and the was allowed stop. The facts relevant for consideration of the instant CRP within bracket IO, comma in brief, are that the present petitioner had filed a title suit before the Court of Learned Civil Judges, Junior Division number 2, Kachar, against the present respondent number 2 to 5. There were 6 defendants.
Lordship 5.
How many defendants were there?
Lordship, as per the Annexure 1, page number 14, the initial title suit is 5 number of defendants, Lordship.
Okay. Defendant number 1 to 5. क्या लिखा? One to 5 as defendants.
Defendant number 2 has not been added as a party here.
Here.
Srimati Saptini Das.
Saptami Das.
He has not been in this picture.
And one more defendant, namely
Defendant number 2, Lordship, Saptami Das.
Srimati Saptami Das, who was arrayed as defendant number 2 in the said suit. However, she has not been made a party in this revision petition. Stop. The present petitioner has sought the relief of declaration of her right, title, and interest over the suit property, as well as for eviction of the said defendants from the suit property, and for permanent injunction against the defendants. Stop. The said suit was registered as title suit number 91/2013. Stop. During the pendency of the aforesaid suit, the present respondent number 1, namely Shri Krishna Sharma. Krishna Sharma is a male or female? Male.
Male, Lord.
Shri Krishna Sharma had approached the trial court by filing an application under Order 1, Rule 10, read with Section 151 of the Code of Civil Procedure, 1908, praying for impleading him as one of the defendant in the said suit. Stop. It was contended in the said application that the present respondent number 1 has taken the suit premises is a room.
Yes, shop premises, one.
Taken the
Not that day.
taken a room. What is the scheduled property in this suit?
Property is, my lord, at page
Bigger.
18, my lord, they have shown one katha, 6 shatak.
Taken a room
Sometimes
situated over scheduled property on monthly rental basis from present respondent number 2, who was the defendant number 1 in the suit filed by the present petitioner. It was further contended that a tenancy agreement was also executed between them.
since 2000. Yeah.
And the present respondent number 1 is running a retail electric goods shop by the name and style Messrs. Anandamoyi in the said premises. It was further contended therein that said premises, stop. Though the present petitioner objected to the said petition, said prayer before the trial court by filing written objection. However, by order dated 10/9/2023, passed in Miss Case number 102/2023, arising out of title suit number 138/2021, the trial court allowed the aforesaid application filed by the present respondent number 1 and directed him to be impleaded as a defendant in the said suit. So the present petitioner was also directed to accordingly amend the plaint. Stop. Being aggrieved by the aforesaid order, the instant revision petition has been filed. Stop. The learned counsel, Mr. S. Chaudhary, the learned counsel for the petitioner has submitted that the trial court had erred in allowing the impleadment application filed by the present respondent without taking into consideration that the present respondent is not a necessary party to this one. He further submits that the trial court also failed to take into consideration that the plaintiff, being dominus litis in a suit, has the option to choose as to who may be pleaded as defendant in the suit filed by him. He further submits that since there is no tenant-landlord relationship between the present petitioner and the respondent number one, the present respondent number one, he cannot be compelled to implead such a person when a suit is already pending before the court, wherein the person to whom the suit was, wherein the other defendants are already parties. He further submits that if the petitioner is able to obtain decree in the suit against the persons from whom the present respondent has derived his right as a licensee, there may not be any requirement of seeking a separate decree against such a licensee, such an unauthorized licensee. He further submits that that in the event if a decree is issued in favor of the present petitioner by the trial court without impleading the respondent number one, and if he remains aggrieved by such a decree, he always have recourse to approach before the executing court by filing an appropriate application under Order 21 Rule 19.8 of the CPC. As such, he submits that the trial court was wrong in directing the impleadment of present respondent as a defendant in the suit filed by the present petitioner, with ignoring the fact that the present petitioner has, being dominus litis of the suit, has the discretion to choose as to whom he may add as defendants. In support of his submission, the learned counsel for the petitioner has cited following rulings. Number one, Vidur Implex and Traders Private Limited and others versus Tosh Apartments Private Limited and others, reported in 2012 8 SCC 384. Number two, NAC Engineering Company Private Limited versus Tarun Keshri Chand Shah, reported in 2026 INSC 8. On the other hand, Mr. G. N. Sahewala, the learned senior counsel for the respondent, submits that the trial court has rightly passed the order of impleading the respondent number 1 as a defendant in this suit, as after considering the fact that it is the present respondent who is in the possession over the suit property since the year 2000 and has been running his business therein after taking electricity connections and
depositing rent, my lord.
and depositing and also by depositing rent in the court after the respondent number 2, present respondent number 2, refused to accept the said rent from him. He submits that this application under Article 227 is not maintainable, as the jurisdiction under Article 227 of this code has to be sparingly exercised and with circumspections. He submits that Order 1, Rule 10 of the CPC gives judicial discretion to the court to add party at any stage of the proceeding, and such a addition may be directed by the trial court if it comes to a finding that the party sought to be added is either a necessary party or a proper party. He submits that in the instant case, since the present petitioner is admittedly in possession of the suit property, he is a necessary party to the suit, and without impleading him, no effective decree may be passed against him. He further submits that impleadment of the present respondent number 1 is also required to avoid multiplicity of litigation, as admittedly the present respondent number 1 is in possession of this suit property. He submits that though the principle that it is the plaintiff who being dominus litis may choose a person against whom he wishes to litigate, is a well accepted principle. However, same is not an absolute principle, and the provisions contained in Order 1, Rule 10(2) gives discretion to the court, in an appropriate case to implead proper or necessary party. He submits that in the instant case, since there is a dispute regarding acceptance of rent between the present respondent number 1 and respondent number 2, there is the suit filed by the present petitioner is a collusive suit wherein the petitioner has deliberately suppressed the fact that the suit, that a shop room over the suit scheduled property is presently in possession of the present respondent number 1. In support of his submission, he has cited the ruling of Apex Court in the case of Mumbai International Airport Private Limited versus Regency Convention Center and Hotels Private Limited and others, reported in 2010 7 SCC 417. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the materials available on record. I have also gone through the rulings cited by learned counsel for both sides in support of their respective submissions. Stop. Reserving the judgment. I'm reserving the judgment. Hearing concluded.
Hello.
Yes.
Please, your lordship. 5 and 6 are analogous. In the next.
Oh, new case.
Yes. In 5, Lordship, my name is not shown, though there is an order, Lordship.
Oh, sir.
Lordship, in 5, Lordship, it is an injury case, Lordship. And 6 is a death case, Lordship. 5 is a handyman and 6 is driver, Lordship. Lordship, I have objections, Lordship, regarding, Lordship, admissions, Lordship. As because, Lordship,
Admission.
Lordship, Lordship, in case 2, Lordship is very much aware in under Workman Compensation, Employees Compensation Act, Lordship, this appeals scope is very limited. Lordship, there must be Lordship, that Lordship payment part, and second is substantial questions. Lordship is page 2, Lordship. Here are Lordship, it is mentions, Lordship, the amount has been deposited. Lordship, but till today, Lordship, I have inquired, Lordship, no amount.
Lordship, this is a mistake I have to clarify. I did not notice this. This I think came from the.
Lordship, page 2, Lordship.
I'll have to clarify this now. I'll have to amend my mind. Please,
Lordship,
we don't deposit. I don't know how this got here. Thank you for pointing out.
Lordship, and next.
Then let him rectify.
I have to rectify this.
Heard Mr. R. Goswami. Learned counsel for the appellant. Also heard Mr. I Hawk, learned counsel for respondent number.
Lordship, in item number 5, the respondent number 1, Lordship.
Respondent number 1 in MFA 55, and in item number 6.
Lordship, in 1 to 3.
In item number 6, 1, 2, respondent number 1, 2, 3. The learned counsel for the appellant has submitted that some typographical error has crept in the memo of appeal, and as such, he prays for allowing him to amend the memo of appeal. The prayer is allowed. Let this matter be listed in the next week. Next week or after 2 weeks. After 2 weeks on a date to be fixed by the ministry.
Lordship, it's given a date, otherwise, Lordship.
Any date. 2 weeks.
2 weeks of this of the 14th September.
Problem. Thank you.
I just pay one office to pay for anything. Item number 10. Yep.
None appears for the appellant on call. Is this matter in the next week on a date to be fixed by registrar?
Item 11.
But this is an appeal for enhancement.
Heard Mr. M. Khan, learned counsel for the appellant. This appeal under, it has been admitted.
Not admitted.
Okay, this appeal under section 173 of the Motor Vehicles Act has been preferred by the appellant/claimant, impugning the judgment and award dated 13/5/2026, passed in MAC case number 62/2020 by the Motor Accident Claims Tribunal of Bhayapuri, North Salmara, Bhayapuri. Stop. The appellant is mainly aggrieved with the quantum of compensation awarded to him. Stop. I have considered the grounds stated in the memo of appeal and have I have gone through the grounds stated in the memo of appeal and have considered the submissions made by learned counsel for the appellant. This appeal is admitted. Let the record of MAC case number 62/2020 be called for the registry to take steps for requisitioning the record. Stop. Let the notices be issued to the respondents. Stop. The learned counsel for the appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 25th September.
Well, not in the cost title, Lordship, my name has not been shown that wrongly. That may be directed, Lordship, my name may be shown.
The cause list. Name of Mr. M. Khan may be reflected in the cause list as engaged counsel for the appellant henceforth.
Item 12.
May it please your lordship. This appeal is against the, there is a caveat.
I have filed caveat, but my name, caveat has not been reflected in the cause list. It is there in the record, Lordship. I am appealing for respondent number 3.
Okay. Appeal is for?
The challenges to the
Only ground is that the ex gratia amount of 25 lakhs rupees, which was admitted, and we have deposed 3 defense witnesses, my lord, in that regard. The official of the CRPF had come and he had deposed, my lord, that the 25 lakhs amount had been disbursed, has been paid to the dependents of the claimant. Lordship will see at page 22, my lord, DW3, page paragraph 30.
So if they get ex gratia, they may not get compensation.
My lord, they will get, but on the
Quantum will-
conventional head and the other, my lord, the future prospect and all these aspects will be paid to them. But this amount has to be deducted from the final amount of compensation.
Heard Mr. R.K. Bhatra, the learned counsel for the appellant. Also heard Mr. M. Talukdar, the learned counsel for the
Respondent number 3, Lordship.
respondent number 3/caveator. This appeal under section 173 of the Motor Vehicles Act 1988 has been preferred by the appellant, namely New India Insurance Company Limited, impugning the judgment and award dated 10/6/2026 passed by the Motor Accident Claims Tribunal number 1, Kamrup Metro, Gauhati, in MSC case number 529/2020, whereby the appellant insurance company was directed to pay an amount of rupees 74,05,140 along with an interest at the rate of 6% per annum to the claimant's respondents. I have gone through the grounds stated in the memo of appeal and have considered the submissions made by learned counsel for the appellant. This appeal is admitted. Stop. Let the records of MAC case number 529/2020 be called for. Stop. The registry shall take steps for requisitioning the records. Stop. Let the notice be issued to the respondents. Since Mr. M. Talukdar has already appeared for
Respondent number 3, Lordship.
and for 1 and 2,
Mother, 1 and 2, some other advocate. Some other advocate before the land tribunal.
have already appeared for respondent number 3. No steps need to be taken for issuance of notice to said respondent. Stop. However, as regards other respondents, the appellant shall take steps for issuance of notice by speed post as well as by usual note within 7 days from the date of this order, returnable on 25th September.
25th September, huh?
Stay, please.
Now, there is an application for stay, my lord.
The stay may be granted subject to release of the entire awarded amount to the respondent claimant number 3, Lordship. So far,
Entire to 3.
1/3. 1/3 of the amount awarded to the respondent number 3, mother of the deceased. Mother of the deceased has not received any amount, ex gratia amount. Only wife received the ex gratia amount. Their document itself shows. Lordship, can you see? They have exhibited the document. The respondent number 1 received the entire 25 lakhs. Either thing.
Yes, Mr. Bhatra. How much comes?
My lord, I have
How much 1/3 comes?
Amount awarded
24 lakhs, it comes to 24 lakhs and odd, my lord.
24 lakh 68,000 80, along with interest, Lordship. No amount should be deducted from her amount.
My lord, may see page number 10, my lord. 11 will be the relevant.
Of the IA. Of the IA.
No, my lord, for the main appeal. my lord. Memo of appeal. my lord. What I suggest at this stage is, my lord, we deposit 50% of the awarded amount, my lord. And since it is only on the question of deduction of 25 lakhs, and if the claimant appears, my lord, the entire matter can be disposed of. my lord. The very recent, my lord, the decision of the apex court, my lord, it
So far as-
clarifies the position of the mother, my lord, as regard ex gratia is concerned.
There should not be any deduction.
आपके favor में बोल रहा है, रुक जाइए ना भाई.
Let him, sir.
There is a decision of apex court, my lord, in 2026, which clarifies this position.
Okay.
That since the rules says that mother is not getting the any benefit of ex gratia, so it was held that the 1/3 which is calculated as a compensation should be kept aside, and thereafter whatever is received as ex gratia is to be deducted, and then the conventional heads are to be paid.
Is it?
My lord.
Ex gratia is to be deducted?
Yes, my lord. Yes, my lord. Lordship will see, my lord.
Okay. Then there may not be any difficulty in disbursing 1/3 to mother.
No, I am not, my lord, objecting to that. What I propose is that I deposit 50%, which comes to around 74 lakhs, will come to 37 lakhs.
Out of that,
let the, my lord, claimant also appear 1 and 2. So that it can be closed, my lord, because we have not challenged anything else. Only ground is that the ex gratia amount should be deducted.
Lordship, mother is also entitled interest.
50% of that
Interest,
can
mother
be
is
taken up.
also entitled interest. Mother is old aged person, widow, 74, around 74 years old.
no. Let them deposit.
Deposit with interest.
In the
We may be
meanwhile, let the widow and children appear.
So 1/3, that is amount awarded towards mother, may be released along with interest. I have a case also. It may be increased, amount may be increased. The amount income considered is on the lower side. Monthly income was 54,000 and odd. The other time considered 40,000 only. And so far as interest on future prospects is concerned, no interest has been given. That is 6%.
No, but this IA, others are also parties.
Lordship.
So we will not disburse it now.
At this stage.
Not today.
Lordship,
We'll direct them to deposit 50% regarding dispersal. Wait for a few more days.
He is not disputing the same.
No, the other side.
Let the claimants also appear. Let there
Other
be a-
claimants also appear.
Lordship. So far as mother.
We will not dispose of this IA.
Well,
we'll keep it pending.
Well,
Heard Mr. R.K. Bhatra, the learned counsel for the applicant. Also heard Mr. M. Talukdar, the learned counsel for opposite party number 3.
Lordship.
Stop. This interlocutory application has been filed by the applicant insurance company in connection with MAC appeal number 450/2026, praying for stay of execution of the impugned judgment and award dated 10/6/2026 passed in MSC case number 529/2020 during the pendency of the connected MAC appeal number 450/2026. Stop. Learned counsel for the applicant insurance company has submitted that the applicant is is agreeable to deposit 50% of the awarded amount as a condition for grant of stay of the impugned judgment and award. Stop. On the other hand, Mr. M. Talukdar, learned counsel for opposite party number 3, submits that since the opposite party number 3 is the mother of the deceased, and since this appeal is directed mainly on the ground, since the connected appeal is directed against the impugned judgment and award mainly on the ground that it did not took into consideration the amount of ex gratia paid to the claimant number 1 by the employers of the deceased. And since the said amount has been admittedly received by opposite party number 1 being the widow of the deceased, and mother did not get any share in the said ex gratia amount, she is entitled to get the 1/3 of the awarded compensation during the pendency of the connected appeal. Hence, he submits that the registry, in the event of deposit of the amount of the 50% of the awarded amount by the insurance company, the registry may be directed to disburse 1/3 of the awarded amount, which comes roughly to 24,68,380 to the opposite party number 3. Stop. I have considered the submissions made by learned counsel. Since there are 4 opposite parties in this interlocutory application and only one has appeared, let the notices be issued to other opposite parties. The applicant shall take steps for issuance of notice on the other opposite parties by speed post as well as by usual mode within 7 days from the date of this order, returnable on 25th of September. In the meanwhile, the execution of the impugned judgment and award shall remain stayed during the pendency of the connected MAC appeal, subject to the deposit of 50% of the awarded amount by the applicant insurance company before the registry of this court within a period of 4 weeks.
6 weeks.
6 weeks from the date of this order. Stop. The question as to whether 1/3 of the total awarded amount may be disbursed to the mother of the deceased, that is the opposite party number 3, shall be decided on the next date after appearance of the opposite party number 1 and 2, namely the widow and son of the deceased. List accordingly.
My lord, can I make one more submission, my lord? Since this matter is only with regard to the deduction of 25 lakhs, other things we have not disputed. May I be permitted to take step through Dusty also to the claimant number
Yes.
1, 2, and 4
The
to expedite the
The
matter?
applicant is also allowed to take steps additionally by way of dusty mode on the remaining respondents. Stop. In the event the applicant is able to serve the notice by dusty mode on the said respondent, it shall submit an affidavit in compliance thereto on the next date fixed, list accordingly.
But can the date be extended in that case because sometime
25th.
24th September it is.
Yes.
A week thereafter also.
Hafta fi Sunday.
But
30 September. Both.
30th of September.
30th of September.
Obliged. This will expedite the matter.
Yes.
Otherwise, interest will be accumulating.
Obliged.
Obliged.
This is an appeal against award of compensation despite there being no permit. So that is the evidence.
Lord Mr. R. Goswami, the learned counsel for the appellant. This appeal under section 173 of the Motor Vehicles Act 1988 has been filed by the appellant insurance company, impugning the judgment and award dated 15/5/2026 passed by the Motor Accident Claims Tribunal Nalbari in MAC case number 178/2023 within bracket injury whereby the compensation amount of rupees 5,66,311 was awarded to the claimant respondent. Stop. I have considered the submissions made by the learned counsel for the appellant and has gone through the grounds stated in the memo of appeal. Stop. The appeal is admitted. Let the records of MAC case number
I'll deposit 50%.
MAC case number 178/2023 be called for from the concerned tribunal. Registry to take steps for requisitioning the records. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 25th of September. IA is also there, na?
Yes, Mr. I'll deposit 50%.
Heard Mr. R. Goswami, learned counsel for the applicant. This interlocutory application has been filed by the applicant insurance company in connection with MAC appeal number 451/2026, praying for stay of execution of the impugned judgment and award dated 15/5/2026 passed by the Motor Accident Claims Tribunal Nalbari in MAC case number 178/2023. Stop. The aforesaid judgment has been impugned in the connected MAC appeal number 451/2026 and the said appeal has already been admitted by this court. Stop. Learned counsel for the applicant submits that applicant is ready to deposit 50% of the awarded amount as a condition for grant of stay of the impugned judgment and award during the pendency of the connected MAC appeal. As such, the notices to the opposite parties is hereby waived and this interlocutory application is allowed. The execution of the impugned judgment and award dated 15/5/2026 passed in MSC case number 178/2023 within bracket injury by the Motor Accident Claims Tribunal Nalbari shall remain stayed during the pendency of the connected MAC appeal number 451/2026, subject to deposit of 50% of the awarded amount by the applicant insurance company before the registry of this court within a period of 6 weeks from the date of this order. This interlocutory application is accordingly disposed of.
Obligation.
May I please, Your Lordship? Input noted at page number 28.
Issue notice HR
H.A.
H.A. Ahmed. Same order. Admit issue notice, take steps within 7 days. Return 25th September returnable date.
Obliged.
15.
May I please, Lordship?
J. Akhtar. Issue notice returnable on 25th September. Take steps within 7 days. Admit. Call for the records. Yes, call for the records. Sixteen. K.K. Bhutto. Same order. Everything same. In IA, we'll issue notice now.
Lordship, in this case, Lordship, we have no liability in this case, Lordship.
So we'll issue notice now. Let them appear.
Lordship.
In IA also notice issued. Next date, 25th September. Same order.